This is Michael Popok, Legal AF. Donald Trump has a new imaginary friend. It's called a made-up presidential immunity, completely made up out of whole cloth, has no basis, in fact, has no basis at all in the literal text of the Constitution or the Supreme Court precedent that ascribes meaning to the Constitution. It would violate the separation of powers, the bedrock upon which our entire constitutional republic is based, the separation between the executive, judicial, and legislative branch. And it would be terrible public policy to allow a then president, now former president, to assert some sort of immunity privilege and immunize himself from criminal conduct in our criminal justice system. But to hear Donald Trump tell it with the filing that he made to the D.C. Court of Appeals, and we can only presume here on Legal AF, the argument that his lawyers are going to make on the January 9th oral argument, he has presidential immunity, again, completely made up in a figment of his imagination, because he will go down in history as a twice impeached president who was not convicted by the Senate. Under our system, under the Constitution, under the impeachment clause, which only deals with the remedy of removing a federal officer from office. Hold that thought. The impeachment clause, and I'm going to read it out loud to you, in the Constitution is our framers' mechanism to remove a federal officer, including the President of the United States, from office. He's indicted, impeached at the House level. He's convicted and tried at the Senate level. You can be impeached and not convicted. Nixon was impeached and not convicted. Clinton was impeached but not convicted. And Donald Trump was impeached twice but not convicted. One of the reasons he wasn't convicted related to the Jan 6 insurrection is that the events leading up to that were in the last 2 weeks of his administration, and there just wasn't enough time to have him tried before he left office. In fact, even though the trial in the Senate went beyond his term, in other words, Joe Biden was already in the White House when they voted whether to convict Donald Trump, many of those in the Senate that voted against convicting him, they did so because they believed they didn't have the power or the jurisdiction to do so because he was no longer president. In other words, what if the president of the United States commits a crime, like a murder, on the very last day in office? There's no time to impeach him. There's no time to go through a trial in this House and a conviction in the Senate. So what do? Well, you then indict him in the real world of the criminal court system, and you let the civil court system do its job, and then that's how justice is done. But not to Donald Trump. To Donald Trump and his filing, because the Senate did not convict him, it's double jeopardy to try him again in the criminal court system. Not only does that fly in the face of the literal text of the Constitution when it relates to the impeachment clause, because that argument is nowhere there, it's actually completely counter to that. It would turn that provision on impeachment and the entire Constitution on its head, which of course is Donald Trump's goal. This is such a wacky legal theory that even Mitch McConnell, when he voted related to the impeachment process, said, we may not be able to get this trial completed before he leaves office, but that's why God created civil and criminal court systems, I'm paraphrasing, and let them handle it after he leaves office. That was Mitch McConnell. When Mitch McConnell is against you as a Republican in MAGA, you know you're in trouble. So what do we have? We've got the argument that Donald Trump is making, which effectively is the following: that since the Senate did not convict him, a president not impeached but not convicted by the Senate cannot be prosecuted for crimes in the regular criminal justice system in prosecutions brought by the executive branch. That's crap. That's absolutely incorrect and against the impeachment clause of the Constitution. Now, some might be wondering out there, Popok. When people wonder, they call me Popok. Popok, when the framers wanted to immunize a federal officer, did they put it in writing inside the Constitution? In other words, do they know how to immunize a federal officer when they want to? Because you just told us that there's nothing in the Constitution that immunizes literally, expressly in language, the president or former president from criminal prosecution. What about others? Do they ever immunize? The answer to that is yes. I'll give you a perfect example. The speech and debate clause. That demonstrates that Congress and the framers of the Constitution knew how to immunize a federal officer when they wanted to. In this case, members of the House or Senate, because the speech and debate clause within the Constitution, in contrast to the non-existent presidential immunity clause in the Constitution, the figment of Donald Trump's imagination, says quite clearly that if a member of the House or Senate, elected official, in the course or scope of their official duties, fact-finding, legislative work, making laws, holding hearings, that type of thing. If they do something, they step in the bucket, wrap themselves around their axle, they can't be sued civilly or criminally as a result. So there's a clear expression by the framers of the Constitution that they know how to immunize when they want to. And guess who they didn't immunize? Presidents who commit crimes. So for Donald Trump to argue ultimately to the U.S. Supreme Court, hey, you've gotten it wrong for the last 200 years. Because if a president is indicted but not convicted, it would be double jeopardy if he was indicted and then convicted in a criminal court. Can't do that. You never take me to the criminal court. Here's the response to that. When you're sitting around the kitchen table, cocktail party, beer with friends, or, coffee on the subway, whatever. Here's what you can tell them. First of all, we have to start with the reading of the actual provision of the Constitution that Donald Trump is attempting to rely on. So let me do that. Let's kick it off with that. The provision says of Article 1, Section 3, Clause 7 of the Constitution, under the headline Impeachment Judgments, very helpfully labeled by the framers of the Constitution. It says, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So let's just take the first half of that clause. All they're doing is telling the world we're dealing with remedy. This is the mechanism to remove and to nail somebody from never holding office ever again, and for them to trust or profit under the United States as a result. That's all we're doing. It's not the criminal justice system. We're not a replacement or substitute for the criminal justice system. We're just impeaching for removal and for disqualification purposes related to that office holder's position. But Clause 7 goes on in the Constitution and says, but the party convicted, this would be Trump, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. In other words, even the framers of the Constitution felt that even if Trump was actually convicted at the Senate level for his role in Jan 6, for example, and got removed from office in the last gasp 2 weeks of his administration, he would still under the Constitution be subject to criminal prosecution by the executive branch of the Department of Justice upon his departure. I don't know how you read that. There is no other way to reasonably read that provision. When the framers took the time and the quill pen to write but, it's almost like saying, for the avoidance of doubt, the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment. That means sentencing at the criminal justice system. That's what the framers said to Donald Trump, who's dumb and dumber along with his lawyers. Aha! So you're saying there's a chance. What's the chance? So their argument is, but I wasn't convicted. Right. And therefore, there's a prerequisite buried and baked in there that nobody can see except me with my magic decoder ring with invisible ink that says, if I wasn't convicted by the Senate, you can't try me in a criminal case. For those that are out there with their local neighbor, child, 8-year-old, bring them into the hot take. Run that argument by them and read that text to them, because that's in a 4th grade education, and see what they say. There is no prerequisite, nor would there be, in the Constitution that a president, former in this case, has to be tried first in the Senate before, as a prerequisite, as a precondition, he can be tried or she can be tried criminally in the criminal court system through the executive branch and the Department of Justice. It would turn the separation of powers on its head. And that's been argued by a series of lawyers who used to work for Donald Trump, who have now filed an amicus brief with the Court of Appeals to argue exactly that, led by Ty Cobb, who used to represent Donald Trump, who said that argument is complete and utter BS. and is inconsistent with the plain literal text of the Constitution. There is no requirement. It would turn that separation of powers on its head because it would emasculate and defang the executive branch from being able to police the presidency within the executive branch, and also would defang the judicial branch from being able to give oversight and checks and balance on the executive branch. If the executive branch leader, the president, could say, sorry, while I wear this magic cloak, I am immune and immunized by the founding fathers and the framers of the Constitution. No matter what I do, even if I pull out this gun and shoot somebody in the Oval Office, you can't get me. You can only get me through impeachment and conviction in the Senate. I can't even get that statement out with a straight face. How the lawyer, and we'll listen to it because it's going to be recorded at the Court of Appeals level, is going to make that oral argument. Good luck. I think that gets shot down in about 30 seconds flat from the 3-judge panel led by Judge Pan. She's speaking of Pan, she's going to pan that legal argument really quickly. I think she's going to be the chairperson of the 3-judge panel that's going to hear these arguments at the D.C. Court of Appeals with Judge Childs on the other side of her. And then it goes up to the U.S. Supreme Court, or maybe it does. I don't know. The U.S. Supreme Court could say this is a ridiculous argument. And if there's not 5 votes to hear it, they'll be like, no. D.C. Court of Appeals looks like they did a good job there. That's why we wanted them to go first. See you guys after March. If you want to take another appeal, we'll be ready. But that's the problem with Donald Trump's imaginary friend immunity argument, is that it turns the separation of powers of this country on its head completely. And it also flies in the face of an entire level of Supreme Court precedent, starting with the Clinton administration, with Clinton and Jones, Nixon and Fitzgerald, Trump recently in the Blassingham case. All of those cases stand for the proposition that, at least on the civil side, that you got to look at the official conduct against the outer perimeters of the president's actions and his job description. And you map the alleged criminal conduct. And if it falls outside the outer perimeter, like it's out here, the constellation is way out here, and it's not within our solar system, that's a crime. And that can be prosecuted, and that can be, indicted and prosecuted. And that's the whole issue right now. Whether on an interlocutory appeal before there is a conviction and a sentencing, can Donald Trump run to appellate court and ask them to dismiss the indictment up front? And that's a very unusual posture to be in. And Donald Trump's not helping himself with ridiculous arguments like this about double jeopardy. It's like, this what do you call it? Kitchen refrigerator magnet law with his lawyers, like just picking out phrases and trying to apply it to the facts. But when you have Article 1, Section 3, Clause 7, which is the clearest pronouncement from the grave of the framers of the Constitution, that there is 2 separate worlds imagined. One, the impeachment process that could, through conviction, lead to removal and disqualification. But that doesn't stop. That's why it says but in the middle. But that doesn't mean that the subject of that impeachment and conviction process can't separately be tried civilly or criminally outside of the Senate and the House. I don't think you can't read it any other way. And then couple that with the fact that the literal language of the Constitution is devoid of any mention of presidential immunity. It's all court-made, case-made, judge-made law under the Supreme Court. They're never, I don't believe, going to extend it this far to stand for the proposition that Donald Trump wants it to stand for, which is I can commit a crime. I could take kerosene and a match and literally burn down the White House. And I am free and clear on the last day. You can't try me in the House and the Senate. So the precondition isn't met. You can't bring a case against me in the regular criminal court system because I was president. Peace out. Does not work. But this, just to make clear, I am not making this up. I'm not making a straw man of a ridiculous argument that is not the argument of Donald Trump. I am giving it to you straight. I'm not blowing smoke or sunshine of exactly what Donald Trump is arguing in his briefing, and that will be taken up by the D.C. Court of Appeals. And so now we've outlined all the reasons why it's against the separation of powers. It's against all the precedent, including some that's been set with Donald Trump's own name on it about how far to extend the immunity. And it is exactly counter to the express language within the Constitution, in particularly the Article 1, Section 3, Clause 7 of the Constitution, the original Constitution, the one done by the framers of the Constitution, not even the amendments done later. And that's the headwinds that Donald Trump is going to have to overcome. His other arguments are no better than that, but I wanted to spend some time talking about the double jeopardy argument so that you understood it and how he's trying to misuse and abuse the language of the impeachment clause within the Constitution. Hopefully, if it ever gets to the U.S. Supreme Court level, the originalists and textualists who love trying to divine meaning from the literal text of this parchment of the Constitution, almost like they're doing some sort of seance with the framers. What did you mean? And looking at the legislative history behind it, we'll look at the literal text and say, well, I don't see any of the secret decoder ring invisible ink here that Donald Trump is proposing, and it's inconsistent with all of our case law, and it would turn our republic on its head. So I'm not going to vote for that. I'm hoping that's where we get. And the Supreme Court, as I'll leave this hot take, can do one of two things. They can either, on a very fast track, after the D.C. Court of Appeals rules, and I think they're going to rule by the 12th, 13th, or 14th of January, very, very quickly. They can take an immediate appeal to the Supreme Court through Chief Justice Roberts, and they can do whatever they want. They can do it within 72 hours. They can do it within 72 weeks or 72 months. They set their own priorities for if they want to take an appeal and how it's going to be briefed and how it's going to be heard. When they want to move quickly, because the republic hangs in the balance, like in Bush versus Gore in 2000, in which they, in a 5-4 vote, gave the presidency to George W. Bush, they can do things in 72 hours that would normally take, like a year. Briefing, oral argument, ruling, 72 hours, boom, Bush is president. That's how it went, off the Florida Supreme Court ruling. Or they can either take it up and do it quickly here and make a decision, no absolute immunity, get back to your trial preparation and go to trial in March, Mr. Trump. Or they can say they can effectively do the same thing by refusing to take the appeal. A writ of certiorari is filed requesting that the Supreme Court take an appeal. But they can say, per curiam affirmed, or we're not taking the appeal on an expedited basis. Go do your trial. Come back when it's over. Let us know how it turns out. And they could do that. I think that they're going to do one of those two things, and they're going to keep the D.C. Court of Appeals ruling virtually intact. We'll continue to follow it on the MeidasTouch Network on this YouTube channel. Help them get to 2 million free subscribers. Yes, it's free. We are the network you've been waiting for, and you can help support it. It doesn't have any outside investors by just free subscribing. And then you can listen to the Legal AF, podcast, which I do every Wednesday and Saturday with Karen Freeman Ignifilo and Ben Meiselas. We pull together hot takes like this one and we debate them for an hour-long podcast we like to call Legal AF. It's exactly what you think. And then you can pick it up on audio platforms of your choice. Give me a thumbs up if you like this hot take. It helps keep me on the air, keeps the ratings high, as they say, for the new year. And until my next hot take into 2024, my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.